We welcome everyone here today for a joint hearing on judicial overreach in the federal courts. Before I recognize myself, I'd ask unanimous consent that members of the full committee, but not of the subcommittees, Mr. Moskowitz and Mr. Biggs, be allowed to sit in and participate in today's hearing. Without objection, so ordered. And as a point of personal privilege, before I make my opening statement, Speaker Gingrich, I've been here now, this is my 25th year on the Hill. Cherish the time I once carried your bag off of an airplane in San Diego and found out you were the speaker, but you were also a regular guy. So with that, I'll now recognize myself for an opening statement. We are here today because a major malfunction in the federal judiciary has been recognized by both Republicans and Democrats. Activist district court judges usurping themselves with their Article III power and imposing on the nation injunctions beyond the scope of what the United States Congress under statute has given federal judges. These rogue judge rulings are a new resistance to the Trump administration, and the only time in which judges in robes in this number have felt it necessary to participate in the political process rather than to participate in the Article III powers given to them both by the Constitution and by statute. President Trump was elected to assert many policies, including the deportation of criminal aliens. He did so publicly and was elected by a majority of Americans and the vast majority of the Electoral College. But he also did so in stark contrast to executive orders of the previous administration. Time and time again, rogue judges have asserted, as though they were 5 of the 9 members of the Supreme Court, their authority when the president was doing nothing more than undoing a policy of his predecessor, one which they seem to have no problem with in the previous administration. Let me be clear, it should never have come to this. It is within the Supreme Court's ability to rule appropriately that judges have exceeded their jurisdiction. Time and time again, the High Court has ruled on the substance of the ruling rather than on the inappropriate nature of an injunction overly broad and affecting hundreds, thousands, or millions of people beyond the plaintiffs before that court. Just last night, a judge halted the administration's plan to end temporary protective status for about 350,000 Venezuelans that Joe Biden welcomed into this country and gave temporary protective status to. Temporary seems not to be a word understood by the court. If President Biden could give protective status temporarily, how, in fact, could it not be the prerogative of the next president to undo that status? Nowhere in that protective status was there an act of Congress or a recognition that temporary equals permanent. This is but the latest outrage coming from lower, or at least I might say the lowest courts. I have said from the start that my colleagues on the other side of the aisle should support this legislation. After all, it was the Biden administration who opposed these universal injunctions and said they were illegitimate. In fact, legislation in the last Congress, authored by a Democrat, is substantially similar to the one that we offer today and would have the same effect. To quote the previous administration's Solicitor General, literally the woman who spoke on behalf of the administration before the court, she said, "The government must prevail in every suit to keep its policy in force, but plaintiffs can derail a federal program nationwide with just one lower court victory," end quote. Those words by Elizabeth Prolongar, President Biden's own Solicitor General, were from October 2024. In other words, after almost the entire 4 years of the Biden administration, they still believed and believed till the end that this was wrong. And yet, we will probably hear today no support on the other side of the aisle. In fact, this is not new, but it is not old. For 180 years of our nation, there were no such injunctions. Only beginning in 1963 did district courts begin to, in relatively small amounts, believe that they could do these without multiple plaintiffs from multiple circuits. From 2001 to 2023, the number grew to 96. But an incredible 64 of those occurred during only 4 years, the 4 years of President Trump, meaning that more than half of all injunctions in this millennium, this century, were against President Trump in his first 4 years. That used to seem like a lot, but during President Trump's first 9 weeks in office this year, he has already faced more nationwide injunctions than President Joe Biden did in his entire 4 years. The federal judiciary isn't interpreting the law. It is impeding the presidency. It is, in fact, not co-equal, but holding itself to be superior. Since Marbury, Madison, there's no question at all that the third branch says it's the last word. And we have accepted that for over 200 years. But that acceptance is for the Supreme Court making a final decision, not one of over 700 district and appellate judges. The reality is every judge is considering himself not to be an associate justice, not to even be the chief justice, but in fact to be a combination of the justice and the president of the United States. This demands that we make a change and make it quickly. When a judge believes that he can order a full plane of criminal aliens back to U.S. soil, essentially saying that 200 years of a statute is to be overturned by his quick order without knowing even who was on the airplane. And finally, demanding that President Trump spend $2 billion in a single weekend. And I repeat, a weekend. And not tolerating any delay because that money was money that that judge believed should be spent, even if it was reckless and illegal. The last one might be understandable because a judge might have misunderstood and thought that President Biden was still in the White House, or that $2 billion, like the $188 billion that President Biden tried to forgive in student loans, and then when thwarted by the United States Supreme Court, found a workaround that he believed was legitimate and gave away another $8 billion in loan forgiveness. No question at all, we had a rogue in the White House for 4 years. Many today will talk about the current occupant of the White House. But in fact, most of the rulings that are being overturned are simply undoing rogue activities of the previous administration. The No Rogues Ruling Act does not eliminate the ability of judges to make decisions. In fact, every decision made by a judge on behalf of a plaintiff would still go forward, but it would go forward only as to the plaintiff in front of him and not a nation as a whole determined by one judge, neither elected nor appointed to a position of sufficient power to speak on behalf of the entire nation. And with that, I would recognize the ranking member, Mr. Johnson, for his opening statement.
Thank you, Mr. Chairman, and thank you to the witnesses for your appearance today. Special shout out to former Speaker Newt Gingrich from the great state of Georgia. Professor Gingrich, good to see you. Of the many troubling actions the Trump administration has taken in its first 71 days, among the most damaging are his authoritarian, dictatorial, and unprecedented use of presidential power to instill fear, intimidate, exact revenge against, and punish those who dare to stand up to him and hold him accountable to the laws of our nation. A climate of fear and trepidation has descended upon the nation. The people of America are more afraid today for our democracy and for their personal safety than ever in our lifetimes. College students have disappeared off the streets paramilitary style by plainclothes, mask-wearing individuals and held incognito for days before they are discovered thousands of miles away in some private for-profit ICE detention facility. Why? For exercising their free speech First Amendment rights. Universities, bastions of free thought, have been punished for having the wrong ideology by having their federal funding revoked. And major law firms that dared to have brought cases against King Trump have been targeted with blatantly unconstitutional executive orders that, if allowed to stand, would shut those law firms down. Unfortunately, mega law firms Paul Weiss and Skadden Arps chose to settle with the king by pledging to represent pro bono only those persons and causes that the king approved of. Shame on them. Then there are other law firms that have stood up to King Trump, and they have challenged his executive orders against them in court, and they have won. Kudos to the lawyers at Perkins Coie, Covington and Burling, and Jenner and Block, among others, for standing up for themselves and for the rule of law and for our democracy. Although federal courts have consistently ruled against these numerous unconstitutional executive orders of President Trump, the mere existence of these retaliatory executive orders should be chilling to all of us. There has been no semblance of due process or fairness in any of these cases. Trump acts first, he deports first, he revokes funding first, he blacklists law firms first, and then questions anyone who challenges him later. Somehow, in spite of this, we are here today to talk about the, quote, overreach, end quote, of the federal courts, not the overreach of the executive branch official who is doing the overreaching. Our Republican colleagues want us to believe that simply because the courts are exercising their Article 3 power of equitable relief to temporarily halt some of Trump's most excessive executive actions, it is a sign of rot in our judicial system, that it is somehow our courts and judges, not the president, who have gone rogue and are overreaching. I disagree, but more importantly, so do the numbers. Since day one of his second term, Trump has attempted to rework our constitutional system of government through presidential fiat, issuing a record 107 executive orders in his first 71 days in office. As I mentioned, many of these executive orders are unlawful or unconstitutional, and the president does not have the power to change the Constitution through executive order, even if his name is Donald Trump. Naturally, they have been challenged in court, and of the over 150 cases filed against the Trump administration, judges have ruled against him 46 times. Of those 46, only 17 are nationwide injunctions. The cases are spread across district courts throughout the country, and judges appointed by Democrat and Republican presidents have all ruled against Donald Trump. What we are seeing playing out in courts across the country today is the judicial system working exactly as it should. America's federal courts have been handed case after case, challenging executive orders standing on questionable legal footing. And yet, the proportionally small number of nationwide injunctions shows the restraint exhibited by the judges considering those cases. I don't know what Donald Trump thought would happen when the cases made their way to the judicial branch, but clearly he has had enough with losing in court. Instead of letting the rule of law play out, Trump and his allies here in Congress now have chosen to go on the attack. Trump and his cronies have called federal judges rogue and corrupt. A judge suggested, or it was suggested that a judge supports terrorists, and they've called judicial rulings judicial coups. MAGA Republicans in Congress have called for judges to be impeached, not because they committed a high crime or misdemeanor, but simply because they ruled against Trump. And far-right media personalities have attacked the judges' families, publicizing their personal information for millions of their riled-up followers on social media. What I had just described is nothing less than a full-scale assault on our entire judicial system, and it is putting judges, their family, and their staff lives at risk. We don't agree on much on this committee, but we should be able to agree that this is wrong, and we should be able to agree to back away from language demonizing the judicial branch, no matter what political party we belong to. Today's hearing is not just about helping Donald Trump undermine the judicial branch, though, well, let me say that this hearing is not just about helping Donald Trump undermine the judicial branch, though certainly it is about that. But Republicans on this committee are sending a message to anyone who dares to stand up to Donald Trump. If you step out of line, they will target you next. We cannot afford to allow what Donald Trump is doing through retaliatory executive orders, through targeting immigrants, through threatening lawyers, through vilifying judges, to become the normal. Our Constitution is being tested, and throughout American history, it has stood up to attempts to weaken its protections. Americans across the country are watching, and they know they didn't vote for Trump to destroy our democracy. They voted for Trump because he promised to lower the cost of living, and Trump has betrayed their trust. Prices are going up, and our economy is headed towards recession as co-President Musk threatens to take away people's Social Security, Medicaid, Medicare, SNAP benefits, and veterans care. Trump is doing nothing to deliver on the promises to the American people. I stand with my fellow Americans, with the federal judges who continue to bravely do their jobs in the face of criticism, and I yield back.
I now recognize the chairman of the Subcommittee on the Constitution and Limited Government, Mr. Roy, for his opening statement.
I want to thank the gentleman from California and my co-chairman on this hearing. It's an important hearing. I thank him for his work on this issue as well as his legislation addressing the matter. And I'd like to welcome the guests who are joining us here today. Appreciate your time, obviously, particularly you, Mr. Speaker, and your great service to this country, and great to have your expertise here. We thank you. And I also want to give a shout out to Cindy Romero. I met Ms. Romero last August in Aurora, Colorado, and I appreciate what she's going to be here to testify about today and her great service. So with that, I would like to take a slightly different angle as the chairman of the Subcommittee on the Constitution than the direction that my friend from California took, because I want to emphasize the judicial overreach we've witnessed over the last 2 months and nationwide injunctions more broadly that are undermining the constitutional structure our founders so wisely envisioned. The nature of the executive branch was a primary point of contention at the Constitutional Convention. Some delegates favored a plural executive, thinking that this arrangement would better preserve liberty. But they were wrong, and our founders wisely resisted their calls. Instead, the Constitution lodges the executive power in a single president of the United States. Alexander Hamilton offered the classic defense of this arrangement in Federalist 70, emphasizing that a vigorous and energetic executive is necessary to defend our liberty from foreign threats. Hamilton rightly argued that unity in the executive was the essential ingredient in this formula. Only a single executive could act with the decision, activity, secrecy, and dispatch necessary to adequately carry out the office. And on a note I have introduced legislation in the past, it's called the Article 1 Act, to try to cabin in the executive branch when it's not necessarily working directly with Congress. And I'm happy to work with my colleagues on the other side of the aisle on these concepts when we have these lingering emergencies. In many cases, these national emergencies that date back to the 1970s. There are times for the Congress and for the legislative branch to assert itself. But the president's authority is at its zenith when we're talking about his actions as commander-in-chief. Injunctions and temporary restraining orders halting presidential actions nationwide threaten the key feature of our constitutional architecture, undermining the core premise of unity in the executive branch, the unitary executive, as we refer to it. Even the most strident proponents of a plural executive at the Constitutional Convention advocated for an executive council of 3, maybe 5 members. Today, in practice, we are governed by an executive council of 678. The nationally elected president and 677 district court judges, each of whom retains a functional veto over executive actions through their power to issue nationwide injunctions. Scholars have long understood that a hostile judiciary or even a single hostile judge could abuse its power to issue nationwide injunctions to infringe upon the lawful authority of the president of the United States. Now, that's not a partisan point. I've got numerous examples of our colleagues on the other side of the aisle who have raised these concerns. The Biden administration's Solicitor General, Elizabeth Prelogar, told the Supreme Court as recently as 2024 that, quote, a court of equity may grant relief only to the parties before it. The district court violated that principle by issuing a nationwide injunction, ... In 2022, Solicitor General Prelogar asked the Supreme Court to address nationwide injunctions as permissible relief in the United States versus Texas, arguing that district courts normally, quote, should only provide relief for the benefit of the prevailing challenger. What happened there was our Democratic colleagues started realizing that when Republicans went to district courts to get injunctions against their president, that suddenly they didn't like it so much. So they were raising concerns. Justice Elena Kagan spoke out against nationwide injunctions by a single district judge in 22, quote, the ability of a single judge to stop implementation of a policy across the country. She stated, in the Trump years, people used to go to the Northern District of California, and in the Biden years, they go to Texas. Just can't be right that one district judge can stop a nationwide policy in its tracks and leave it stopped for the years that it takes to go through the normal process. Former United States Rep. Mondaire Jones introduced the Injunction Reform Act in 2022. I could go through the quotes that he offered, but I won't. I can offer those for the record without objection. In a letter to William Torrance dated June 11th, 1815, Thomas Jefferson explained who decides constitutional questions. Certainly, there is not a word in the Constitution which has given judges that power, authority to decide on the constitutionality of a law more than to the executive or legislative branches, meaning we all have an obligation and a role to do that. Questions of property, of character, and of crime being ascribed to the judges through a definite course of legal proceedings, laws involving such questions belong, of course, to them in the judiciary. And as they decide on them ultimately and without appeal, they, of course, decide for themselves the constitutional validity of the law. In other words, our founders never intended the federal courts to have the ability to unilaterally decide constitutional questions, as these judges are unelected and were never given the power to legislate from the bench. Treating the courts as the final authority on public policy, grants them more power than even Madison's rejected Council of Revision proposal at the Constitutional Convention. Indeed, it happened regularly during the first Trump administration, as we pointed out. Now in the second Trump administration, it is on steroids. As of last week, district courts had issued no fewer than 17 nationwide injunctions against administrative actions, with scores more temporary restraining orders, or TROs as we call them, as barring the president from enacting the agenda upon which he was elected. Alexander Hamilton wrote in Federalist 78 that even the Supreme Court would wield neither force nor will over politics, indicating he never envisioned the judiciary having the final say on every political decision or action. Now these injunctions and TROs have even infringed upon what the Supreme Court has described as conclusive and preclusive presidential powers, including core presidential authorities to conduct foreign affairs and repel invasions. Now, I have got numerous examples of what we've been dealing with. Just so people know, this is a 56-page summary that I've got of the 158, it might be 159 now, because we're having to track them on a daily basis, lawsuits against the administration and against the president for carrying out the agenda upon which he was elected. 17 injunctions. I think there are a great number more TROs. And the cases we're talking about, without going through all of them, nationwide TRO enjoining the Trump administration from freezing foreign assistance funding enforcement order requiring the administration to pay approximately $2 billion within 36 hours. That's a judge singularly acting against the president's actions. Another one, provisionally certifying a class and adjoining the Trump administration from deporting members of a foreign terrorist organization. A nationwide injunction adjoining the Trump administration from pausing, terminating, or amending any equity-related grants or contracts, DEI. A nationwide injunction enjoining the Trump administration from prohibiting federal funds from being spent to promote gender ideology. A nationwide TRO enjoining the Trump administration from prohibiting biological men from being housed in women's prisons. 2 injunctions regarding the administration for implementing an executive order considering transgender individuals in the military, birthright citizenship, issue after issue after issue that the administration is trying to act on according to the campaign upon which he ran. One in particular has earned the scrutiny it has received. Just 2 weeks ago, Judge Boasberg of the District Court of the District of Columbia ordered the administration to stop the deportation of members of Tren de Aragua, a violent Venezuelan gang that has terrorized cities and towns across the country. At this table, in this room, we heard testimony from Alexis Nungare, whose daughter Jocelyn was murdered by TDA in the suburbs of Houston. Right here, we heard her powerful testimony about what that gang has done to this country. We're going to hear from Ms. Romero today about what that gang did to her community in Aurora, Colorado. And here we have a single district judge who's asserting jurisdiction from the District of Columbia to tell the President of the United States that he cannot deport members of the violent TDA gang out of this country to keep our streets safe. That is not what is supposed to occur. Today's hearing, where we'll learn from constitutional scholars and real Americans about what is wrong with the current system, is a good start. We should carefully study whether Congress should push back against judicial overreach using its constitutional power to structure and fund the courts. Our Constitution did not create a plural executive or judicial tyranny. Today, we're far too close to both. With that, I yield back.
The gentleman yields back. We now recognize the subcommittee ranking member for her opening statements, Ms. Scanlon.
Thank you. Like the chairman of the subcommittee on the Constitution, as ranking member, I too would like to address the constitutional concerns raised by this hearing. Our Republican colleagues have called this hearing today for one reason, because this White House, this president continues to lose over and over again in court. As people and groups from across the political spectrum challenge the barrage of unconstitutional and illegal executive actions taken by this White House in just the first few weeks of this term, because it doesn't matter if the judges were appointed by Bush or Biden or Obama or Reagan or by Trump himself. When the president attempts illegal or unconstitutional actions, United States judges, guided by the letter of the law, must rule against him. It's a confirmation of the total subservience of today's Republican Party to this president that their response to multiple judicial rulings of executive overreach is a hearing entitled Judicial Overreach and Constitutional Limits on Federal Courts, when we should be holding a hearing on presidential power grabs and constitutional limits on executive power. This is Civics 101. The Constitution provides in Article 1 that Congress writes the laws. In Article 2, the president administers the laws. And in Article 3, the courts interpret the laws. Our Republican colleagues are concerned about the unprecedented number of successful lawsuits challenging this president's executive overreach. But it's not the actions of the courts in interpreting our Constitution and laws that are unprecedented. It's the scope and breadth of this president's executive orders that are unprecedented. It's this president's attempt to go it alone, to usurp the power of Congress and we the people, to rewrite the laws of this country and the Constitution, and to reserve unto himself, rather than the judiciary, the right to interpret the laws and our Constitution. The sheer volume of unconstitutional and illegal actions taken by this president in just the first few weeks of his term has led some to wonder if the president fundamentally misunderstands the nature and terms of his Article 2 powers. Specifically, when Article 2, Section 3 says that the president shall take care to faithfully execute the laws passed by Congress, does this president think that the word execute means that he's supposed to kill laws rather than carry them out? Unfortunately, the underlying rationale for much of this action is a radical theory set forth in Project 2025 and elsewhere. It's one that would vest federal power in a unitary executive, sidelining two of the three co-equal branches of our government, Congress and the judiciary. We're here because Republicans who control the House and Senate have, thus far, chosen to abandon their constitutional duty to constrain an out-of-control executive branch. If they don't see anything wrong with it, their constituents do, and more of our colleagues would know that if they actually showed up at town halls in their districts. Our Constitution is built upon the rule of law, that no one is above the law, and our legal system is built on the idea of judicial independence. In the past 2 months, we've seen our judicial system working as the founders intended. And as the Supreme Court ruled in Madison versus Marbury over 200 years ago, it's the job of our judiciary to declare laws and executive actions unconstitutional if they're in conflict with the Constitution. The federal judges who've ruled against President Trump's unlawful power grabs are simply interpreting the Constitution and the laws passed by Congress to protect the rights of the American people. To suggest otherwise is to substitute a theory of executive primacy that is completely at odds with our constitutional history and separation of powers. Mr. Chairman, I wish that we could dismiss today's hearing as just political theory or theater, but the stakes are too high for the American people and their rights hang in the balance. While this administration has begun by attacking people it vilifies, including immigrants, students, or working people, no one should kid themselves. It's clear the rights of every American are at stake. When the White House and some of our colleagues claim the right to deny due process to immigrants who they claim have broken a law, that's a sham. Because if you don't support the rights of immigrants to due process, then you don't support anyone's right to due process. Because without due process, the government can do whatever it wants to anyone, including citizens, and they aren't able to defend themselves. What's to stop ICE from saying that Mr. Roy or Mr. Jordan is a member of a violent gang and shipping them out of the country? Attacks on our courts, whether in the form of executive orders punishing law firms and lawyers that dare to stand up for the rule of law, or hearings like this attempting to constrain the courts, or tweets urging impeachment or violence against judges, are part of a broader attack on the rule of law. Our Republican colleagues have shown that they're not concerned about civil rights and the rule of law. Their sole concern appears to be whether or not a federal judge has ruled against this administration. They've gone so far as to call for impeaching judges who rule against this White House, eliminating courts altogether, or advocating to cut off funding for the court system. The fact is, if the president wants to end his legal woes, he can simply follow the Constitution and our laws. Because if a president issues illegal executive orders, the courts are duty-bound to block them. But rather than accepting that reality, our Republican colleagues would rather hand the president the keys to unchecked authoritarian power. Let's be real. Americans elect a president every 4 years, not a king. Even if President Trump had won a landslide electoral victory, which he didn't, that would be beside the point. An electoral victory does not justify running roughshod over the courts and the Constitution, which every president is sworn to uphold. Presidential power is not absolute. When President Trump empowers Elon Musk to ignore laws Congress passed or slash funding Congress appropriated, he's undermining the power of the American people who voted us into office. If President Trump's agenda is as popular as he claims, he can work with his allies in Congress to convince the American people to support it. But he has no right to simply do whatever he wants just because House and Senate Republicans don't have the backbone to stop him. Democrats and independents are standing up against President Trump's blatant power grabs because if he can deny the rights of some people, there's nothing stopping him from denying the rights of all people all across America. And that should concern everyone in this room and everyone across this nation. I yield back.
Gentlelady yields back. We now recognize the chairman of the full committee for his opening statement, Mr. Jordan.
Thank you, Mr. Chairman. Who decides? That's the fundamental question. Who gets to make the call? Is it the guy whose name was on the ballot, or is it some bureaucrat? Is it the guy who got 77 million votes or some district judge? The left always says, trust the bureaucrat, trust the judge. It's the Faucis, it's the Boasbergs who get to make the call. After all, they're the experts. They're smarter than we, the people. They're smarter than all us hillbillies in flyover country who voted for President Trump. Trust them. That's not how it works. We, the people, have the power. And you know what's interesting? For all the left's talk about democracy, they don't really trust it. Last summer, they kicked their nominee off the ballot without a vote, without an election, and they put someone else on the ballot without a vote, without an election. So of course they like some judge issuing orders or injunctions that stop the head of the executive branch from doing what he said he was going to do when he ran for the job and when the American people elected him. Think about it. Here in DC, an elected judge thinks she's better equipped to determine military readiness than the commander-in-chief. An unelected judge in California thinks he gets to decide how many probationary employees work in the executive branch, not the guy who was elected to run the executive branch. Another unelected federal district judge here in DC thinks he gets to decide how long illegal gang member terrorists stay in our country, not the president, not the commander-in-chief. And now that same judge gets randomly assigned the Hegseth case, and he'll get to determine who the Secretary of Defense can talk to and how he has to do it, not the president. I think Americans see through this all. They know Representative Iss's legislation is exactly what's needed. They know who they elected, and they want him to make decisions that affect the executive branch, that affect our country. So I want to thank our chairman, Mr. Issa and Mr. Roy, for this hearing. I want to thank Mr. Issa for his bill. Mr. Schmidt, a member of our committee, who we put his amendment on that bill, which I think makes it even stronger. We passed that legislation 4 weeks ago. It's going to be on the floor tomorrow. It's going to pass the House. I want to thank our witnesses for being here. Ms. Romero, what you've went through, thank you for coming. And of course, Speaker Gingrich, for your half a century of service to the Constitution and the country, thank you for joining us. That is the question, though. Who decides? The individuals that we, the people, elect, or someone else? I yield back.
Gentleman yields back. We now recognize the ranking member of the full committee, the gentleman from Maryland, Mr. Rossi.
Thank you very much, Mr. Chairman, and thanks to our witnesses for joining us today. So why have 34 federal judges from 11 different districts with a combined 474 years of service on the bench, judges appointed by Presidents Reagan, Bush, Clinton, Bush, Obama, and Trump, entered 57 different preliminary injunctions and temporary restraining orders against President Trump and Elon Musk's executive orders and actions, like the ones nullifying constitutional birthright citizenship, unilaterally dismantling congressionally created agencies, or impounding and diverting funds appropriated by Congress. Well, the majority says it's because these are radical judges. And they lead off, as our good Chairman Issa did, with Judge Jeb Boasberg, the chief judge of the District Court of the District of Columbia, who enjoined the mass roundup and deportation of immigrants to an infamous El Salvadoran prison in peacetime without any due process at all, allegedly under the Alien Enemies Act of 1798, a statute explicitly limited to wartime and military invasion. Some of our colleagues have been railing against Judge Boasberg for ordering the planes to be turned around. They say those planes were filled with terrorists, I think my good friend from Texas said. Well, here's one person of many who wasn't a terrorist on that flight or a gangbanger. His name's Kilmer Garcia. He's a Marylander married to a U.S. citizen who has a 5-year-old son with autism. And he went to pick up his son, but he was picked up first by ICE. And then he was shackled and put on that airplane and shipped off to the torturers of El Salvador without ever having the benefit of those two most beautiful words in the English language, due process. He never saw a judge. Nobody ever told him what he was being charged for. Nobody ever told him that there were any charges against him. And he was sent to a mega prison run by the self-proclaimed dictator of El Salvador. And yesterday, you know what happened, Mr. Chairman? The Trump administration admitted that it had made a mistake. He was not actually a gangbanger. He was not a criminal. It was all a mistake. If there'd been due process, maybe that would have been determined, but there wasn't. But they put him on that plane in El Salvador. Well, all's well that ends well, right? No. The administration says there's nothing they can do about it now because he's no longer in U.S. custody. This guy who lives in my state, married to a U.S. citizen with citizen children, he's stuck with the dictator of El Salvador. Well, Judge Boasberg, some of our colleagues want to impeach him. Look, some of our colleagues, they've got for wanted signs in the Cannon House office building with the names and faces of judges on them. They want to impeach them now. They want to impeach Judge Boasberg. Some of my colleagues should be alerted to this fact. Judge Boasberg was first named to the bench by President Bush. He was Justice Kavanaugh's roommate at Yale. Known in legal quarters as a very conservative judge, but they want to impeach him because he stood up for the rule of law. Now, Democrats say all of these executive orders and actions are being struck down not because these are radical left rogue judges, but because the judges, regardless of who appointed them, are doing their jobs. If the number of decisions striking down Trump illegality is unprecedented today, it's only because the sheer number of illegal acts committed in the first 100 days is unprecedented. America's never seen anything like it before in our entire history. Trump and Musk have been systematically violating the Constitution and breaking the law to trample the rights of the people and steal our data, fire excellent federal workers en masse, and dismantle congressionally created government agencies and programs, from the VA and Medicaid to NOAA, NIH, and Social Security, which Elon Musk called, quote, the biggest Ponzi scheme of all time. When brave Americans go to court to defend themselves against the President of the United States and the richest man in the world, these judges from across the political spectrum are showing up to work, and they're showing America why we have an independent judiciary. And yes, I've got to tell my friend Chairman Jordan that even if you campaign on doing something unconstitutional, like naming people kings and queens, or stealing other people's money, no, that doesn't make it constitutional, even if you campaigned on it. And the vast majority of the things here, I never heard of them campaigning on. But in any event, it's irrelevant to the job of the courts. Anyone who's read any of the decisions knows that what we're witnessing today is a matchless constitutional crime spree by a rogue president and his Doge enforcer, a government contractor who has pocketed $38 billion from the taxpayers, multiples more than he has ever even claimed to have saved us. And we know how Doge makes typos, converting millions into billions. Read the decisions. Look at these cases, finding that Trump violated Congress's spending power and usurped our lawmaking power under Article 1. Read the cases, finding that Trump violated the First Amendment free speech rights, the Fifth Amendment due process rights, the Sixth Amendment counsel rights of the people, even by discriminating by name against law firms and lawyers, actually banning specific firms and lawyers from federal buildings and courthouses, federal contracts, and federal employment, all simply because they dared to represent their clients, and Trump hates them. Now, out of this mountain of cases, which I can only surmise our colleagues have not read, let's zero in on Trump's executive order contradicting the very first sentence of the 14th Amendment, which says that any person born or naturalized in the United States and subject to the jurisdiction thereof is a citizen of the United States. Trump got struck down by a Reagan judge, a Biden judge, an Obama judge, and a Bush judge. The Reagan judge said, quote, I've been on the bench for 4 decades. I can't remember another case where the question presented is as clear as this one. This is a blatantly unconstitutional order. Blatantly. This is from a Reagan judge. Now, my colleagues seem to think that an executive order is greater than a law or the Constitution itself. But an executive order cannot trump a federal statute, much less the Constitution. An executive order is just an order to the executive bureaucracy to follow a policy unless and until it's countermanded by law, by the courts. Many of our colleagues are following Trump and Musk in calling for impeachment right now. There have been only 15 federal judges impeached in all of American history, always for serious professional misconduct, like taking bribes, stealing from the court, or habitual drunkenness, not even occasional drunkenness, habitual drunkenness on the bench. Congress has never defined a doctrinal or interpretive disagreement as a high crime and misdemeanor, much less when the judge's reasoning was airtight, correct. The spreading movement to impeach and attack judges is so alarming that Chief Justice Roberts issued a rare statement last week. He said, for more than 2 centuries, it's been established that impeachment is not an appropriate response to disagreement concerning a judicial decision. The proper response, of course, is to appeal the decision. And to be fair, Chairman Issa expressed his strong disapproval of these wanted posters yesterday in the Rules Committee. Now, for some members, talk of impeaching these so-called rogue judges is just fun and games. But the vicious assaults, the vicious rhetorical assault on the judiciary has turned into something more sinister in certain quarters. Actual violent threats, bomb threats, direct intimidation. Judge Boasberg, the Bush appointee, must endure scandalous online attacks and insults by President Trump and Elon Musk and their followers. Even worse, the campaign of vilification has spread to Judge Boasberg's family, including outrageous attacks on his daughter, who's had her photo and her place of work posted on social media by Elon Musk to his 290 million followers. These threats follow an actual bomb threat made to the sister of Supreme Court Justice Amy Coney Barrett. And there are numerous other threats taking place today. And of course, we've seen threats and actual violence and murders take place in the past. I call on my colleagues right now to call off the campaign to impeach federal judges for doing their jobs. I call on them to demand that the Trump administration comply with all judicial orders while appealing whichever ones they want to appeal, and to demand the return of people unlawfully taken to El Salvador on that so-called plane full of gangbangers. And I especially call on them today to denounce all violent threats, doxing, online vilification, and threats against our judges. This is the Judiciary Committee of the United States House of Representatives, and we should act like it. I yield back, Mr. Chairman.
I thank the gentleman. I ask unanimous consent that the official statement by ICE officials agreeing that there was not 100% accuracy in Mr. Garcia's arrest, that in fact he was a prominent member of MS-13, a different recognized terrorist group. Without objection, so ordered. Without objection, all other opening statements will be included in the record. I'd now like to introduce our distinguished panel, beginning with the Honorable Newt Gingrich. Mr. Gingrich is the former colleague here in the House and served from 1979 to 1999, including 4 years as the Speaker of the House. Speaker Gingrich was instrumental in formulating Contract with America and returning Republicans to a House majority after 40 years of Democrat control. Since leaving the Congress, he has remained incredibly active, and in fact, in both policy, politics, and government, he has led, having authored several dozen books and teaching military officers and other national security professionals at the National Defense University. Welcome, Mr. Speaker. Mr. Paul Larkin. Mr. Larkin is the John Barbara and Victoria Rumpel Senior Legal Research Fellow at the Edwin Meese III Center for Legal and Judicial Studies at Heritage Foundation. Before joining Heritage, Mr. Larkin served in various positions in the Department of Justice and at the EPA, and as a Senate staff. He has spent a number of years in private practice and is most prepared for today's hearing. Welcome. Ms. Cindy Romero. Ms. Romero is a resident of Aurora, Colorado, who saw firsthand the effects of soft on crime and open border immigration policy. She was a resident of an apartment complex targeted by Tren de Agua and eventually was forced to move after her neighbors were reportedly victimized and her car was struck by gunfire. Lastly, Professor Kate Shaw. Ms. Shaw is a professor of law at the University of Pennsylvania, Carey Law School. Professor Shaw focuses on executive power and the Supreme Court, along with other issues. I want to welcome all of our witnesses and ask that you please rise to take the pledge to be sworn in. The right hand. Do you solemnly swear or affirm under penalty of perjury that the testimony you're about to give will be the truth and correct to the best of your knowledge, information, and belief? So help you God. Please be seated. Let the record reflect that all witnesses answered in the affirmative. Okay. We'll begin with Mr. Larkin, and I would only ask, you've all seen this on C-SPAN, but to the greatest extent possible, please wrap up by the end of 5 minutes. You'll have the indicator on your desk, but your entire statements will be included in the record, as will additional information, which I can't speak for everyone, but I know the speaker will revise and extend with considerable authentication. Mr. Larkin. I think check and make sure you're on and pull it a little closer, perhaps.
Is that better?
Much.
The practice of issuing nationwide injunctions outside the confines of a certified nationwide class action is mistaken as a matter of law and unwise as a matter of policy. Let's start with the law. And in there, let's also start with the Constitution. The legislative power is granted to Congress. And what is the primary product of that legislative power? It is what the Constitution defines as a law. The term law also shows up in Article 3, but it shows up in Article 3 under the phrase arising under the Constitution, the laws, or treaties. It is not the courts that are responsible for creating the law. It's the courts who are responsible for interpreting it as it applies. But they can only do so in the context of a case or controversy. Two structural limitations on what the courts can do. In other words, in order for the courts to be able to say what the law is, they have to get on the playing field. And in order to do that, you have to have a case or controversy. Now, why does that matter? Well, the Constitution does speak to this. As I've said, only the Congress can create a law. Anytime a court enters a judgment that is tantamount to being a law, the judge has gone too far. And in the case of nationwide injunctions, a judgment in favor of non-parties goes too far. You also have no statute in the Judicial Code, no provision in the Constitution, and no settled history at common law that allows the judge to enter these sorts of orders. That's important because everything has to fit into one of those three. Why? The Supreme Court has interpreted Article 3 in light of how it was understood in 1789. And so those are the three primary bases that you have to look to: the text of the Constitution, statutes, and English common law history. In fact, there are two Supreme Court cases that directly undermine the legitimacy of nationwide injunctions outside of certified class actions. One is Williams versus Zabarez. In that case, the court said there is no case or controversy between two parties that are in a case over an issue that has not been put into dispute by one or the other of them. It logically follows that there is no issue in dispute between someone who is a party and someone who is a stranger to the entire litigation. Similarly, at the back end of the process is the case of United States versus Mendoza, where the Supreme Court held that the federal government is not subject to the win or go home rule that you see in the NCAA postseason tournament. The government isn't stuck with whatever loss it has the first time it litigates a case to a final judgment and loses. The doctrines of the law of issue preclusion or collateral estoppel, the new and old terms, do not apply to the federal government. Why? The Supreme Court, in a unanimous decision in Mendoza, said they do not. Why? Because there are a variety of good policy reasons why it shouldn't. With that, then let me turn to the policy reasons that show this practice is unwise. There are several, okay? First, mandatory injunctions prevent the percolation of issues in the lower court that the U.S. Supreme Court in Mendoza said is necessary for that court to be able best to resolve whatever legal dispute there is. It allows the court to be sure that all of the issues, all of the sub-issues, all of the arguments pro and con, all of the benefits and costs of whatever rule are fully aired. Secondly, it encourages judge shopping. All you have to do is find one favorable judge, and you can stop an entire administration in its tracks. And as you know, it has happened to every administration over the course of this 21st century, from the George W. Bush administration to the present. Each party has been subject to this practice. Third, it can result in conflicting nationwide judgments. You can wind up with injunctions going one way and the other way because a court in Maine and a court in Alaska can come out the opposite way in a case. Finally, they are going to weaken the doctrine of stare decisis, because as the Supreme Court comes to realize, if it has to decide issues at a preliminary stage of the case without the guidance of the lower courts, they're going to have to overrule some of their decisions. Let me end where I began. This practice is mistaken as a matter of law and unwise as a matter of policy. Thank you.
Thank you. Speaker Gingrich.
Thank you, Chairman Issa and Roy, Ranking Members Johnson and Scanlon, and all the members of the subcommittees for allowing me to testify. There is clearly a potential constitutional crisis involving the judicial branch's effort to fully override the legislative and executive branches. 15 district judges effectively seized control of various executive branch duties in the first 6 weeks of the current presidency through nationwide injunctions. This is potentially a judicial coup d'etat. It clearly violates the Constitution and more than 200 years of American history. To set the stage for this hearing, let me mention 12 former federal judges appointed by President John Adams: Richard Bassett, Egbert Benson, Benjamin Bourne, William Griffith, Samuel Hitchcock, Philip Barton Kay, Jeremiah Smith, George Keith Taylor, Oliver Wilcott Jr., Williams McClung, Charles McGill, and Williams Tillman. President Adams appointed these federal judges on his way out of office to hamstring the incoming President Thomas Jefferson's agenda. President Jefferson concluded that impeaching the judges would take too much time. He and the Congress simply abolished the courts in which they served via the Judiciary Act of 1802. This is a constitutional balance of power. The legislative and executive branches can reshape the judiciary branch. It is a useful reminder in considering the current situation. Unelected lower court judges have been steadily grabbing power for years. It was such an obvious threat that in 2012, Vince Haley and I wrote, "Bringing the Court Back Under the Constitution." It is an historic study which I am submitting for the record. According to Harvard Law Review, there were 96 nationwide injunctions ordered by district courts from 2001 to 2023. 2/3 of them, 64, were issued during President's time in office. Furthermore, 92% of the injunctions against President Trump were issued by judges appointed by Democratic presidents. Since January 20th, 2025, lower courts have imposed 15 nationwide injunctions against the current Trump administration. This is compared to 6 during George W. Bush's 8 years, 12 during Barack Obama's 8 years, and 14 during Joe Biden's 4-year term. The notion that unelected lawyers can micromanage the executive branch and override a commander-in-chief who received 77.3 million votes should trouble every American. This is particularly troubling for issues of national defense and public safety. Around 500 BC, Sun Tzu asserted in The Art of War that, quote, "Speed is the essence of war." How can the United States have speed in national security issues if opponents can judge shop to find someone ambitious or arrogant enough to block, repudiate, or delay the president's decisions? There are 677 authorized district judgeships. How many think they can override duly elected presidents? This summary statement has 4 propositions. First, the courts have often been challenged. President Jefferson wrote, quote, "Judges as the ultimate arbiters of all constitutional questions would place us under the despotism of an oligarchy," close quote. President Andrew Jackson was in constant fights with the Supreme Court. President Abraham Lincoln made the Dred Scott decision expanding slavery a centerpiece of his 1858 senatorial campaign. In his first inaugural, President Lincoln warned that if the Supreme Court held supreme rule, quote, the people will have ceased to be their own rulers, having to that extent practically resigned their government into the hands of that eminent tribunal, close quote. Second, as the Judiciary Act of 1802 proves, the legislative and executive branches can constitutionally defend their rights, and they have in the past. It is historically and constitutionally wrong to think the legislative and executive branches are helpless against judiciary actions. Third, the Supreme Court could intervene to eliminate this attack on the executive branch by district judges. Chief Justice Roberts could end the growing confrontation by establishing a rule that any nationwide injunction issued by a district court against the executive branch would be suspended in implementation and immediately taken up by the Supreme Court. This would remedy the lengthy appeals process. Fourth, the Congress and the President can take decisive steps toward bringing the judiciary back into a constitutional framework. This hearing is a good first step. There could be a series of hearings on the constitutional and historic framework, which ensures no single branch of government can acquire dictatorial powers, specifically the judiciary and this committee. These hearings would educate the members and the American people. They would create a national understanding of the need to defend the Constitution against overreaching branches of government. I would also recommend that the Congress pass Chairman Iss's No Rogue Rulings Act, which is a good signal to the courts that they have gone too far. Thank you, and I look forward to your questions.
Thank you. Ms. Romero.
My name is Cindy Romero. I'm a wife, a mother of 5, a grandmother of 3, a part-time worker and student, and a former resident of Aurora, Colorado. I'm one of the many victims across the nation of the violent transnational gang, Tren de Aragua, and a former lifelong Democrat. My husband and I resided at the Edge of Lowry apartment for 4 years. And while the first few years were a pleasant experience, we soon began observing changes in our once quiet neighborhood. And in the spring and summer of 2024, we noticed shuttles dropping off large number of illegal immigrants onto the property. Throughout the year, we watched in horror as a few apartments full of migrant families quickly evolved into large groups of gun-toting, military-aged males, threatening the remaining leaseholders into abandoning their properties, then kicking in the doors to the many vacated units to make room for other gang members. Open-air drug use, drug dealers, and seemingly underage prostitutes filled the common areas of the buildings. Large parties in the parking lots lasted well into the morning. Stolen and abandoned vehicles blocked residents' cars, property damage was evident, and random shootouts soon began to be expected on our block every night. These criminals brought in unlicensed electricians to run electricity to abandoned apartments and locksmiths to change the locks on the outside of the buildings to deny access to the owners, emergency services, and even the leaseholders of the building. Despite several calls for help to the Aurora Police Department, they often provided conflicting excuses for not responding. For example, one officer told me that he wanted to respond, but was instructed not to. Or they were often responding to other rampant crimes across the city, or had to respond to any crime in my neighborhood with no less than 3 or 4 officers and an armored vehicle. One officer suggested I go to the media because he felt sorry for me. He likely unintentionally saved my life. Although we were low income and barely paying our bills, we realized the need to invest in home protection, and we purchased 3 additional handguns and 6 cameras in the event that we had to defend ourselves. And during June and July, the gang members slowly began to torture us through intimidation, loud arguments, physical conflicts outside our door every night, vandalizing, taking over vacant apartments on our floor, And after several confrontations with the gang members, several calls, and submitting video evidence to the Aurora Police Department with no results, we gave up trying to stop them from squatting on the property. We spent the next few weeks looking for another rental, and we were unable to locate another low-income property rental that didn't have the same exact issues that we were facing every day. We reached out to local mainstream media, several NGOs in our community begging for help, only to be turned away because we were just ordinary taxpayers. There were no government programs to grant citizens temporary protected status from imported gangs in our own country. On August 18th at 11:21 p.m., 10 minutes after my now viral video was recorded, a young man who I called my friend was mortally wounded outside my apartment during a firestorm of bullets, causing thousands of dollars in damages to cars and surrounding properties by 6 gunmen later identified as Trendere Agua. And thanks to the heroism of one local Aurora City Councilwoman named Danielle Durinsky and some of her friends, including John Fabricatori, they'd been sounding the alarm over TDA for months while being called a liar and ignored by their governor. I was finally able to escape these horrible conditions due to their help. In the media frenzy following the video release, many TDA members have now been identified and arrested all over the country. Danielle Durinsky has never received an apology or acknowledgement for exposing the threat. When I heard that Mr. Trump had taken an interest in Aurora and our struggles with Trendere Agua, I was relieved. I was hopeful that a change was, getting ready to happen, that it was on the way, that it was impending. And as president, he did not disappoint me. And I feel safer knowing that our country becomes more secure daily. I continue to think that the lives of my family and many others in my community were put at risk by the Biden administration's failed sanctuary policies at the southern border. Sanctuary status puts citizens at risk. And we must stop pushing ideology over common sense. Thank you.
Thank you. Would you show the video before we move on, please?
It's scenes coming out of a movie as the Venezuelan gang Trendere Agua are seen breaking into apartment complexes in Aurora, Colorado. This is according to our sister station in Denver. There you can see the group well armed and forcing an apartment door open and making their way in. This has raised concerns amongst residents and Colorado state law enforcement officials.
Thank you. Professor Shaw.
Chairman Issa, Ranking Member Johnson, Chairman Roy, Ranking Member Scanlon, Chairman Jordan, Ranking Member Raskin, and distinguished members of the subcommittees. Thank you for the invitation to testify today. My name is Kate Shaw. I'm a professor of law at the University of Pennsylvania, Carey Law School. I understand that the purpose of today's hearing is to discuss recent judicial rulings against the Trump administration and to evaluate some of the responses to those rulings being considered by this body, in particular, resolutions of impeachment against federal judges and a bill that would limit the power of district courts to issue nationwide injunctions. Let me say at the outset that in my view, the premise of this hearing, that courts have overreached or transcended the limits of their authority and that this overreach calls for some response, is badly mistaken. It is true, as has already been noted this morning, that the Trump administration has been on a losing streak in the federal courts. A recent analysis by Professor Steve Vladeck found that of the 151 cases brought against the Trump administration since January 20th, 46 have resulted in some sort of preliminary relief. That relief has been ordered by judges across the country and by judges appointed by presidents of both parties. This broad consensus makes clear that despite the claims of some critics, these rulings do not grow out of substantive disagreements with President Trump's policy choices. The lawsuits have been brought and have overwhelmingly succeeded because many of the challenged actions have been taken without regard for and often with outright contempt for both statutes and the Constitution. And by that, I mean both the constitutionally required process for lawmaking and the rights the Constitution commands government to respect. First, as to process. Article 1's lawmaking provisions are pretty straightforward. Laws must be passed by both houses of Congress and signed by the president or repassed over a veto. Laws governing funding, that is appropriations, are laws like any other. As for Article 2, it has long been settled that when the president acts, it needs to be pursuant to some authority Congress has granted or within one of the narrow areas in which Article 2 gives the president the authority to act without congressional authorization. That is the heart of Justice Jackson's concurring opinion in Youngstown, still the most influential judicial account of presidential power. What all of that means is that if President Trump wished to reshape or even eliminate many federal agencies, or dramatically reduce government expenditures on foreign aid, or eliminate job protections for federal workers, or roll back federal privacy protections, working with his many allies in Congress, including those on this committee, was the constitutionally permissible way to do that. Instead, he has ignored the laws passed by Congress and the constitutional rules that give Congress primacy in lawmaking. Beyond those largely procedural failures, many of the administration's initiatives have flouted core constitutional principles: the freedom of speech and expression, due process, equal protection, equal justice and equal protection under law. President Trump has used the power of government to exact retribution against individuals and entities who have engaged in constitutionally protected activities, and he has brought the full weight of the state down on vulnerable groups the Constitution protects. In short, this administration has been marked by a breathtaking degree of presidential unilateralism that is flatly inconsistent with the Constitution and with numerous statutes passed by Congress. That is true in general terms, and it is true as to specific actions. That is why President Trump has fared so badly in court. To be sure, some of these rulings will be, some already have been, reversed on appeal. Reasonable minds can disagree about some of these questions, but rather than focus on the appellate process or on correcting the legal defects, this administration and many of its supporters have suggested that the problem is district judges. And rather than use its constitutional authority to enact laws that would give the president the power to do some of the things he wishes to do, this body has devoted itself to two things: stripping the power of federal courts to issue injunctions and pursuing the impeachments of federal judges who have merely discharged their obligation to uphold the Constitution. To my mind, the district court judges who have ruled against the administration have not come close to engaging in high crimes and misdemeanors, the constitutional standard for impeachment. And although Congress has considerable power to regulate the federal courts, including potentially restricting courts' ability to issue nationwide relief, the current moment calls for caution in pursuing change that would curtail courts' ability to meaningfully review and remedy unlawful executive action. It has been suggested already this morning that rulings against the administration thwart the will of the people. But democracy does not begin and end with elections for president. It includes elections for membership in Congress, the branch closest to the people and the entity whose authority many of these decisions protect. Democracy also means more than just elections. It includes values like the ability to engage in speech and expression, to associate, to petition. Meaningful democracy also requires genuine political equality, procedural fairness, and mechanisms for the protection of minorities. And in our system, courts can be a key guarantor of those aspects of democracy. They are doing their part to preserve both law and democracy. Other branches of government should join them. Thank you again for the invitation, and I look forward to your questions.
Thank you. We'll now go in order, out of order, in order to give Mr. McClintock the first round of questioning.
Thank you, Mr. Chairman. The ranking member offers us an example of an upstanding, law-abiding Marylander in the case of Brego Garcia. As Mr. Ice has said, Mr. Garcia has been identified as a member of MS-13, the most violent criminal gang on the planet. And there's one report just published that he's implicated in human trafficking in this country. Not exactly Rotary Club material, I think. But shouldn't the circumstances of his case be examined in an individual action before a district court and not dumped into a far-reaching edict arising from another case that has very different circumstances? Mr. Larkin, what's your opinion of that? Your microphone.
How about now? My mistake, sorry. My understanding is these actions that have been challenged under the Administrative Procedure Act, not as actions seeking federal habeas corpus relief. Federal habeas corpus is the traditional remedy that someone uses when they're claiming the government has unjustly seized them. There's even a provision for next friends.
And that option exists in law, and I think that's the appropriate option, is it not?
The Administrative Procedure Act is not.
Yes.
For example, you can't use Section 1983 to challenge the legitimacy of your conviction. You have to use the Habeas Corpus Act.
Right.
So while
again, these are individual cases with very different individual circumstances and ought to be.
that's right. I mean, what you have, a particular John Doe, number 1, 2, 3, whatever. Each case has to be examined separately, but it should be in habeas corpus, not the Administrative Procedure Act.
Mr. Gingrich, I'm told that 92% of the judges who've issued blanket injunctions against the administration have been appointed by Democrats. That at least suggests a rather partisan tilt to all this, and it's not being done even-handedly. What's your view of that? And doesn't that undermine public confidence in our courts?
Well, I think if you look at the recent reports from various polling firms, clearly a majority of Americans believe that no single district judge should be allowed to issue a nationwide injunction. And I think that when you look, my judgment as a historian, this is clearly a judicial coup d'etat. You don't have this many different judges issuing this many different nationwide injunctions, all of them coming from the same political ideological background, and just assume it's all random efforts of justice. This is a clear effort to stop the scale of change that President Trump represents. And I agree, a lot of this stuff can be fought out. Some of it should be fought out in the Congress, but it shouldn't be micromanaging the executive branch on national security issues by random single judges who have no standing, they have no particular knowledge, they haven't been in the room, they don't know what the consequences of what they're doing are, and they put both Americans and the nation at risk when they intervene to become basically alternative presidents. You now have potentially 677 alternative presidents, none of whom won an election.
Well, we all believe in due process. Every injured party should have access to the courts, and they do. The question is whether a single district court can go beyond the case before them and apply the same decision to others whose cases are not before the court in jurisdictions that go far beyond their own. Mr. Gingrich, you've pointed out that there are several ways to address this. One is congressional action. The other is the Supreme Court putting its own house in order. In fact, the Alito dissent recently suggests that there are at least 4 of the justices who very much want to do this. It seems to me that's the cleanest and most surgical route, assuring that the rule is done from within the court and not imposed by legislation. What are your views on what the Supreme Court should do and on what you've already mentioned what we should do?
Look, I think the Chief Justice would achieve far more for judicial independence if he cleaned up his own judiciary rather than lecturing the rest of us. And I think there are ways he could intervene, as I mentioned in my testimony. They could establish a rule that any nationwide injunction issued by a district court will be held in abeyance and will be immediately appealed to the Supreme Court. Lincoln makes this case. Very head-on fight, which is ironic because Chief Justice Taney, as Attorney General for Jackson, had ruled against the courts. And it said, as Attorney General, the courts cannot order the president. Now, he then becomes Chief Justice, extends slavery potentially to the whole country, and is lectured by Lincoln in his first inaugural as Taney sits there. And Lincoln is essentially saying, this was the law of the case, not the land, and we will not enforce it. And they don't. They never enforce Dred Scott. And so I think Chief Justice should think seriously about intervening to preempt any requirement for something such as Chairman Iss's bill, which I support strongly, but would be no reason to have it if the Chief Justice did his job.
Thank you.
I thank the gentleman. I now ask unanimous consent that the previously played video be placed in the record. Additionally, I ask unanimous consent that the Wall Street Journal article entitled "Why Judge Boasberg's Deportation Order is Invalid, Legally Invalid" be placed in the record, and that the Harvard Law Review article entitled "District Court Reforms, Nationwide Injunctions" be placed in the record. Without objection, so ordered. And we now go to the ranking member, Mr. Johnson, for 5 minutes.
Thank you, Mr. Chairman. I'm reminded of the quote that goes something like, "When the law is not on your side, argue the facts. And when the facts are not on your side, argue the law. And when neither is on your side, then pound the table." Well, Trump doesn't have the facts or the law on his side. And so with this exercise today, he is vicariously pounding the table. Professor Shaw, President Trump has targeted and attacked some very wealthy and powerful entities to send a message to the less powerful. Trump has attacked Columbia University. He has attacked the white shoe, silk stocking law firms like Paul Weiss and Skadden Arps. These powerful, wealthy entities can afford to sue to protect their interest and our rule of law. But instead, they chose to lay down and get steamrolled by the bully. Professor Shaw, how does laying down and getting steamrolled compromise the rule of law and undermine our democracy?
Let me just say that, there have been targeted entities, right, including a number of law firms that have, in fact, not laid down, that are, in fact, taking a strong position of resistance to what they believe to be the unlawful components of some of the targeting orders. So law firms including Wilmer Hale, Jenner and Block, Perkins Coie, have made their responses and their views of the impermissibility of the targeting of law firms for no reason other than their decision to take on disfavored representations and to advance legal arguments that the president has personally objected to and sometimes been on the receiving end of. And so, I do think that calling out clearly unlawful executive action is critically important, particularly for entities with resources and stature. And I think that it encourages the targeting in unlawful ways for institutions to refuse to take a stand. I think that the orders targeting law firms are clearly unlawful. I think that some judges have already so found, and I think that the judges that rule on those orders will continue to find that. And the last thing I'll say is I think that law firms that have decided not to fight and that are complying haven't bought themselves any security necessarily. I'm not sure there's any guarantee that they won't be subject to further targeting simply because they have acquiesced in sometimes coercive terms in the first instance.
Yeah, when the bully knows that he can bully you, then he's going to continue bullying you until you stand up. And so I'm glad that these other law firms and other academic institutions have and are standing up. What would happen to access to justice for the least of these if these very wealthy and powerful entities that are being targeted today, if each and every one of them laid down and just allowed themselves to be steamrolled?
I think there could be a chilling effect in the willingness of law firms to take on disfavored representations. The targeting has not been limited to law firms either, right? There has been an effort to suggest that sanctions will be sought by the Department of Justice against nonprofits and other legal actors that have engaged in litigation against the administration. And so it does seem quite clearly designed to reduce the amount of courageous litigation against and challenges to executive action. And so, I think that the potential costs for the rule of law are, incalculable.
Yeah, because it's based on the adversarial system. And if you wipe out the adversaries, then you wipe out the adversarial system or the adversary system.
I think that's right, that attacks on look, lawyers are not always popular, right? So attacking lawyers is not something that everyone is always going to object to, but judges need lawyers to present arguments to them. And our system of justice and the rule of law requires lawyers to take on representations, including potentially unpopular representations. So I do not think these attacks on white shoe law firms should be understood as just about white shoe law firms. I do think they are attacks on the very idea of access to justice and to the rule of law.
And when you attack, in addition to the lawyers, you attack the judges and claim that they need to be impeached, not for committing high crimes and misdemeanors, but for simply ruling in a way that is against the bully. What impact does that have on our justice system and our democracy?
I worry that the intent there is the same, to basically have a chilling effect on the willingness of judges to rule against the administration. In the same way, I think part of the intent of these executive orders is to create a climate of fear and intimidation and to disincentivize taking on representations, including against the federal government. So I think the intended effect is likely the same.
Thank you.
Thank you.
I yield back.
Gentleman yields back. We now go to the gentleman from Kentucky, Mr. Massey.
Thank you, Mr. Chairman. This hearing reminds me of a breakfast I had with Antonin Scalia. About a dozen of us congressmen invited him to breakfast, and this was about a decade ago when Obama was the president and John Boehner was the speaker. And my colleagues appealed to Scalia and said, what can you do? You need to get involved here. The courts need to get involved. Obama's running roughshod over Congress. And Scalia refused to accept that premise. He said, no, this is not my job to referee fights between your two branches. My job is as a jurist to decide if somebody's been harmed and what the remedy is. And occasionally we interpret the law and the constitutionality of it. He said, and by the way, you're the most powerful branch of government. I don't know what you're complaining about. All the tools you need to restore the balance are in the Constitution. And one of my colleagues protested that impeachment was just too hard to pull off, given the threshold in the Senate and the political backlash. And Scalia shook his head. He said, I'm not talking about impeachment. Y'all have the power of the purse. You are funding everything you complain about that Obama is doing. Just quit funding it. And it was a pretty clear message. Now, that was about tension between Congress and the executive branch, and our hearing today is about tension between the judicial system and the executive branch. But I think it's still the case that what Scalia said is true. Let me give you an example of something I'm going to predict is going to happen in the courts soon that I'm not going to have much sympathy for on the president. So the president recently had a press conference and said he's going to wind down the Department of Education. Oh, great. That's my bill. I've got a one-sentence bill that eliminates the Department of Education. I should be very excited about this. The problem is much of the activity that he says he will undertake, he just signed into law the funding of it a week before. We did a continuing resolution that fully funds every single penny of the Department of Education then a week, and the president signed it. This is, as Professor Shaw pointed out, appropriations bills are laws too, and they require both chambers and then the president to sign it. And so it's an appropriation bill, it's a law, it's in law, and a week later, he announces that he doesn't like some of the law, and so he's going to do things differently. So that's my problem that I have. Now, I do think it's a good hearing, and this is a great question. I tend to think that probably there are cases where they shouldn't have nationwide injunctions, but this is a double-edged sword. Under the Biden administration, he did unconstitutional and unlawful things during COVID that were stopped with nationwide injunctions. So for instance, he had a rent moratorium that was stopped until the Supreme Court eventually basically said it was illegal. He refused to grant religious exemptions to the vaccines in the military. There was a nationwide injunction. Actually, one of the attorneys in that is a constituent of mine, Chris Wiest, who stopped all of the vaccine mandates at that point in the Air Force. That was a nationwide injunction. And then his OSHA vaccine mandate was stopped with a nationwide injunction. So I'm torn on this. Maybe if we just don't have nationwide injunctions, people in certain districts can live under tyranny or the perception of it. And if you're in a different judicial district or circuit, you get some remedy from the tyranny. Maybe it works out better that way. Maybe we should have tried each of these cases in each of these courts and found out the answer. But Mr. Speaker, former Speaker Newt Gingrich, what do you have to say on since you were Speaker and led this appropriations process, do you think the president can unwind the Department of Education a week after he signed the bill that funded it? Yield to.
Well, as you know, when I was Speaker, we balanced the budget, something you believe in, for 4 straight years, the only time in the last century. So I think I can talk with some authority about this. I suspect there will be a real fight at the Supreme Court level over whether or not the president has impoundment authority, which was taken away during the collapse of the Nixon presidency, but had existed before that. That'll be a legal fight. I think your point about injunctions is semi-right. That is, a court should be able to issue the injunction. My point about this, the Chief Justice, is if that particular single district judge says this is a valid injunction, if they immediately went to the Supreme Court and then the Supreme Court agreed that it was a valid injunction, then you could have a nationwide injunction. But I'm with Lincoln, who said even though the court had decided 7-2 that slavery could be extended nationally, he refused to accept the legitimacy of that decision because it wasn't unanimous. Now, so the precedent is pretty clear. I think your instinct is right. There are times you need a nationwide action. My only point is, if the district judge says that, the following morning it should be in the Supreme Court, and the Supreme Court should have to render judgment. If they agree, then you have a nationwide injunction. But if they say, no, you're in error, then there's no nationwide injunction.
Makes sense to me. I yield back.
Thank the gentleman. We now go to the ranking member of the full committee, Mr. Raskin, for 5 minutes.
Thank you, Chairman Issa. Respect for the separation of powers is intertwined with respect for due process of the citizens. The gentleman from California essentially invited us to accept the deportation of someone from America without any due process at all, which the administration has admitted was a mistake because now he's hypothesizing that person belongs to a different criminal gang and engaged in other different hypothetical crimes. And obviously, the reason why we have due process is because we can't try these cases in the Judiciary Committee of the House of Representatives. But just reading from a court document here, Plaintiff Abrego Garcia is not a member of, nor has any affiliation with Trenta Aragua, MS-13, or any other criminal or street gang. Although he's been accused of general gang affiliation, the U.S. government has never produced any evidence to support this unfounded accusation. He has no criminal history. He's never been charged or convicted of any criminal charges in the United States. So who knows? That's why we have due process. This shouldn't be just fodder for cable TV. We're talking about people's lives here. Professor Shaw, what does due process actually mean? And should Judge Boasberg be impeached for saying that the Alien Enemy Act of 1798 doesn't apply because we are not at war and we have not suffered an invasion by a foreign power?
The core components of due process are straightforward, right? And it involves some notice and an opportunity to be heard, right? To make some sort of case in your own defense prior to deprivation of life, liberty, or property. So that's in the Constitution. Due process applies to every person, not just to citizens. And due process doesn't look identical if we're talking about due process in the context of potential deportation or due process in the context of, a change to your Social Security benefits, right? Due process is deeply context dependent. And all Judge Boasberg has ruled as a preliminary matter in this case is that some sort of process has to be afforded before this potentially irreversible act occurs. Judge Boasberg has not ordered anyone released in the United States, has not objected to the detention of the covered individuals, has simply said, provide reasons and an opportunity to respond. And
follow the law, right?
And follow the law. And it seems from public reporting as though there is real reason to believe that errors were made.
My colleagues are calling for the impeachment of Judge Boasberg. Has there ever been a federal district judge, a federal appeals court judge, or a U.S. Supreme Court justice impeached because someone disagrees with the content of their ruling?
We have no tradition of impeaching judges based on the contents of their rulings.
We impeach them for bribery or corruption or habitual drunkenness on the bench. Speaker Gingrich, by the way, do you agree with the Republicans and with Donald Trump and Elon Musk who are calling for the impeachment of these judges? That's a yes or no.
I actually agree with Jefferson that impeachment is a cumbersome and difficult process, virtually impossible to achieve, which is why
So you oppose the impeachment?
Which is why Jefferson abolished 14 courts, because you could
Okay,
abolish them
Professor Shaw,
by
forgive
simple
me.
act of
You remember the 5-minute rule. I've got no more time. It's a yes or no question, and I didn't get an answer from you. The Chief Justice Roberts has said that the correct response to disagreement with a district court decision is to appeal. I just heard Speaker Gingrich call this a judicial coup d'etat, and he said the Chief Justice should stop lecturing the rest of us. Who's right? Is it Newt Gingrich or is it Chief Justice Roberts here?
In this instance, Chief Justice Roberts, we have no tradition of impeaching judges. Appeal is the remedy for disagreeing with the district judge. Or if it's a statutory ruling that's wrong, Congress can respond, right? If it's if there's a bias or misconduct issue, there are disciplinary processes and complaints that can be brought against judges. You can seek to recuse or a remand to a different judge. There are many remedies our system affords if there is some sort of problem with the judge presiding over a case. But impeachment has never been in that toolkit.
Do you believe that there has been a conspiracy for a coup d'etat among 34 U.S. federal district court judges appointed by Presidents Reagan, Bush, Clinton, Bush, Obama, and Trump?
No, as you said, I think these judges are simply doing their jobs.
The only comparable case I can think of here is the impeach Earl Warren movement after Brown versus Board, where there were racist segregationists who wanted to impeach Earl Warren because they did disagree with the content of his opinion. What happened with that? And do you think that he should have been impeached?
As far as I know, there were non-impeachment resolutions introduced at that time. There was rhetoric, there was critique. And to be clear, criticizing judges is absolutely healthy in a democracy. I am not suggesting otherwise, but this is already a pretty serious escalation to have seen these resolutions introduced. I really don't think they should go any further.
Thank you. I yield back, Mr. Chairman.
Thank you. We now go to the gentleman from Wisconsin, Mr. Fitzgerald, and I would ask if I could have 15 seconds of his time.
I yield back to the chairman.
Okay. Mr. Speaker Gingrich, I just have one short question, and it is a yes or no, unlike the other one. In your 2 decades as a member of Congress, did you see members of Congress put bills in of any sort because they were popular and felt strongly within their district, whether or not they were moving anywhere?
Of course.
And that would include things like impeachment, whether they were likely to succeed or not.
They're political symbols, not legislative symbols.
Very good. I thank you. I thank the gentleman from Wisconsin.
Reclaiming my time. Mr. Larkin, nationwide injunctions, they're relatively new phenomenon, right? It's, isn't that correct?
Yes.
Yeah, it's fair to say nationwide injunctions became more commonplace in the 60s and 70s. And that is because Congress began authorizing general rulemaking by federal agencies, such as passage of Clean Air Act or the Clean Water Act.
Well, there are several factors that led to the late development of it. One is a change in philosophy of what it meant to say that something was unconstitutional. For example, Professor Samuel Bray explained this at length in his article. Traditionally, when a court said something was unconstitutional, it meant the government could not enforce it against you. Over time, courts gradually began to say, no, that means you can't force it against anybody. The problem is that overlooks the role that a district court judge has both horizontally and vertically within the federal system. No one district court judge can bind the appellate court or the Supreme Court. No one district court judge in Maine can bind a district court judge or any judge in Alaska. And so, unfortunately, this practice developed, and we didn't have anybody stepping back and saying, no, wait a minute, are there constitutional, statutory, et cetera, limitations on it? And it has actually hurt both parties because each party has suffered through this process.
Thank you. Speaker Gingrich, as you mentioned in your testimony, between 2001 and 2023, there were 96 nationwide injunctions issued, of which 64 were granted against President Trump. Well, why do you think the courts have issued nationwide injunctions against President Trump with such frequency? It's kind of a question we're all pondering right now.
You know, one of my favorite books on the law is The Bramble Bush, which is the 1929 introductory lectures at Columbia Law School, and which draws a distinction between the law as it is practiced and the law as it is written. So let's just, at a common sense level, be honest. Donald Trump represents a profound, fundamental shaking up of a very deeply resistant establishment, which can be traced back to Franklin Roosevelt in 1933. You take on a system that's almost 100 years old, the system fights back. The last great bastion of power held by the left is district court judges and their allies on the Supreme Court. And they're behaving, as a historian, this is a perfectly natural thing. They're doing everything they can to stop the president, who was elected by millions of Americans. They were elected by no one, but under our system, they have a certain amount of power. Not nearly as much as the modern legal system believes, because the 1958 decision by the Supreme Court, which said we are supreme, is baloney. The Supreme Court is supreme in Article 3. It is not supreme over the whole Constitution. And I think we're now going to face a genuinely important, historic conversation as a country about whether or not unelected judges on a randomized basis, who happen to be 92% Democrat, have the power to stop the elected commander-in-chief on item after item after item. My guess is the American people will say to the legislative branch, you got to be kidding me. And if Justice Roberts wants to cut this off, he should act now, because this is going to get worse, not better.
Thank you. Mr. Larkin, I'll just finish up with a quick question about forum shopping. It's something that's clearly been happening, and we're used to it at the state level within the judiciary as well as at the federal level. I was wondering if you had a comment about that.
Sure. I mean, the problem is attempted to be avoided by having random assignment. But unfortunately, there are some times when there's only a limited number of judges in a particular district. And as the result, if there's only one, that's who you're going to get. If there are two, you have a 50% chance. And people wind up doing this, not surprisingly, because they think Judge A is going to give them a better likelihood of success. Now, you know, that's bad enough when what you're talking about is a damages action, because that damages action is going to result in a check, perhaps, that goes just to one party. It's different when you're talking about having one judge in any one town enjoying the entirety of the federal government across the nation. That's a much more severe problem. And that's why this is a reasonable effort to cabin that. And, you know, picking favorable judges is a reason why.
Thank you. I yield back.
Thank the gentleman. We now recognize the gentlelady from California, Ms. Lofgren, for 5 minutes.
Thank you, Mr. Chairman. It seems ironic that today's hearing is titled Judicial Overreach and Constitutional Limits on the Federal Courts. Because if we really care about constitutional limits, we should start by confronting the recent attacks on judicial independence, attacks that themselves defy the Constitution. In the past few months, we've seen Elon Musk, President Trump, and even members of Congress call for the impeachment of judges, not for misconduct, but because they don't like their rulings. And that's not how a constitutional democracy works. You know, it's true that members of the judiciary were not elected by the Electoral College. That is beside the point. As my colleague, Mr. Massey, pointed out, when Congress enacts a law, signed into law by the president can overturn that law with a statement, which is essentially what an executive order is. And that judges are making that finding is the role that they have been assigned. Now, Professor Shaw, the recent federal court decisions, which, by the way, have been made by judges appointed by both political parties, have led to calls for the president's supporters to impeach these judges. Now, only 15 federal judges have been impeached by the House since 1804, and only 8 had been removed by the Senate. I was involved in one of them for a very severe misconduct case. What's the standard in the Constitution for impeachment for a federal judge?
Well, it's been understood that the impeachment, the constitutional language of treason, bribery, and other high crimes and misdemeanors applies with full force to federal judges, although it's actually not explicit in the Constitution, and there are some scholars who have raised some questions about it. But our practice is consistent that that is the same standard that applies to other officers. It applies to judges. And in terms of how our practice has implemented that standard, it has been exactly as you said. In the 15 judicial impeachments that have resulted in 8 convictions and removals, they have been for serious misconduct, things like habitual drunkenness, sexual assault, or corruption, bribery, those types of offenses. The one impeachment of a Supreme Court justice, Justice Chase, was somewhat different because it involved explicit partisanship from the bench. But there you had repeated jury charges and actually kind of electioneering from the bench that also clearly distinguish the conduct at issue there from any of the rulings at issue here. So just to be, succinct, none of these historical examples have anything to do with the substance of the rulings rendered by the judges who were subject to impeachment.
Well, and even for those who cite the section of the Constitution that judges serve during times of good behavior, that wouldn't include disagreement with the outcome of a case.
No, I would say the combination of the good behavior language and the impeachment language has suggested that the way to implement the requirement of good behavior is through impeachment. There is no other mechanism that we have ever used to remove judges other than the impeachment mechanism. And certainly there's nothing to suggest that disagreement with a ruling, whether we're talking about as a matter of good behavior or the specific impeachment language, would ever be the basis for seeking to remove a federal judge.
Senator Chuck Grassley, chairman of the Senate Judiciary Committee and hardly a bleeding heart liberal, recently said, and this is a quote, "You can't impeach a judge because you disagree with their opinion." I take it you agree with Senator Grassley's statement there?
I do.
Now, would doing so be damaging to our constitutional system of separation of powers? And if so, why would that be?
I do want to be clear that I think that there is a healthy interbranch debate and dialogue that can include criticisms, including sharp criticisms of the rulings handed down by district judges, appellate judges, Supreme Court justices, and that can include hearings that consider and maybe adopt legislative change, right? Obviously, Congress has considerable authority to regulate the jurisdiction of the federal court. So I don't think any of that is unhealthy or destructive, but I do think that moving into an era in which substantive disagreement with the rulings of federal judges gave rise to impeachment proceedings would involve an escalation of this kind of interbranch warfare and a politicization of the judiciary that would be extremely damaging to judicial independence and to the role of courts in our democracy.
Thank you very much. Ms. Romero, I found your testimony riveting, and I'm sorry that you and your neighbors went through such a nightmare. There is not a single member of this committee on either side of the aisle that doesn't want violent criminals who in this situation to be deported. The issue is standing up for the rule of law, making sure their due process when that is done. And I want you to know that I listened very carefully to your testimony. I'm sorry what you went through.
Thank you very much.
Thank you. We now go to the chairman of the full committee, Mr. Jordan.
Thank you, Mr. Chairman. Professor Shaw, so was Judge Boasberg correct when he said turn the plane around?